The Constitutional Court has barred President Jacob Zuma from being a candidate in this election and therefore being a member of the National Assembly. Spread the fire. Welcome to SMWX. Let's get into this today. Oh, and by the way, a reminder to help us get to 100,000 subscribers before the election. Let's go. Spread the fire. Welcome back to SMWX. And my. The Constitutional Court today ruling that President Jacob Zuma will not be a candidate for the MK party in this election and is disqualified via the Constitution from being a member of the National Assembly. So, in this episode, as always, we're going to break down exactly what this means, have a look at the court's reasoning, and also think through what this means legally and, most importantly, politically for this election. So, I think the first thing is let's look at the background and the importance of this case vis-a-vis other cases. We know that the MK party, as well as the IEC and ANC, in different cases have been at loggerheads in the courts. The MK party won the challenge to make sure that they could be a registered political party. We also know that they won the case dealing with the trademark of the MK party, the use of the name and the logo. Although that's being appealed, I don't think it will be appealed before the election. And then we had this third case where the MK party had won at the electoral court that President Jacob Zuma could in fact be a candidate on the list of the National Assembly. That was appealed to the Constitutional Court. We heard arguments and we've done a series of videos explaining the different issues in that case. But today I really want to focus on the Constitutional Court's decision, some background features of that decision, and the decision itself, as well as its political implications for the election. So firstly, I was interested that Justice Theron was the justice who read out the judgment and seems to have penned the judgment. Now, why is that interesting? Justice Theron dissented in the case that's now known as Zuma 2, the case where former President Zuma was sent to jail. She didn't necessarily say he shouldn't go to jail. She just thought that a more typical criminal trial should have ensued rather than a direct imprisonment from the Constitutional Court. And she also dissented in the rescission judgment. So she has typically been a judge who has been on the other side of the court when it comes to these Zuma matters. And therefore, it was interesting for her to write this judgment. It was almost a statement from the court to say that the court is united, and even a justice like Justice Theron, who has dissented before in this case, stands with the full court. I think it was also interesting that it was a full court, that it was a unanimous judgment. I actually haven't been able to read the full judgment because at the time of publication, it hasn't been released to the public yet, but I watched very carefully the statements made by Justice Theron. And we will look at the judgment in its full depth in due course. But interesting that it was Justice Theron, interesting that it was unanimous. We knew that they had already dismissed the recusal application, but they gave us some reasons for that, effectively that the court felt that the presumption of judicial impartiality hadn't been superseded. So let's look at the judgment. As soon as I heard Justice Theron talking about, quote, the rule of law, I knew which way this judgment was going. And I think the court saw this as an attempt, try as they might to deny it, to kind of vindicate their earlier judgment. And that judgment was based on this idea that Zuma had violated the rule of law by showing contempt to the highest court. And so this judgment was couched in the language of a kind of vindication of the rule of law as the highest ideal. There were a number of decisions. So the first was on this decision of appealability. Since Section 47, the relevant section of the Constitution, envisages an appeal process in its proviso, the MK and Zuma argued that, and Justice Zondi of the Electoral Court argued that since he was not afforded an appeal, because this case, the case where he went to jail was one which went directly to the ConCourt, and the ConCourt decided, so there was no appeal. They argued that since the proviso of this section envisages an appeal, this wasn't the kind of sentence that was envisaged in Section 47(1)(e), the relevant section of the Constitution which disqualifies. The court effectively found, look, this was a conviction, it was a sentence, and just because there was no provision or option for an appeal doesn't mean that Section 47(1)(e) doesn't apply. It just means that this is a scenario in which there was no appeal. And so Zuma lost that. There was a question of remission. And this is where I happen to feel that the commission was on the weakest ground, because the Electoral Court had held that a remission alters the sentence. What the Constitutional Court found, which overturned the Electoral Court, is that a remission doesn't alter the sentence itself, only time imposed. So they've gone with a kind of weak understanding of what remission is. It's interesting because it invokes separation of powers questions, because the president does have very wide powers in Section 84(2)(j) of the Constitution to alter any sentence and pardon, reprieve, and then remit any fines, punishments, or forfeitures. But the court finding here that pardon is the strong power, where you can extinguish a sentence and a conviction, whereas remission doesn't even extinguish a sentence. It simply just changes the time served. So according to the court, the remission did not alter the sentence imposed by the court. It simply changed the amount of time Zuma served. Interesting. I'm not so sure about that, but it'll be interesting to read the court's judgments and the court's reasoning. I know the commission based a lot of their submissions around what are called the travaux préparatoires, and those are kind of constitutional assembly conversations and discussions, whereas Zuma based his submissions largely on the text of 84(2)(j, as well as some case law. So it'll be interesting to see how the court went on that, and whether the foreign law also played a role in their determination. Then there were a few more arguments. There was an argument about bias, where the court asked for further submissions. They ultimately found that Janet Love's statement around President Zuma, as she was asked a question, would he be eligible? She basically said anyone in that position would not be eligible. And the court found that it was ambiguous enough not to directly implicate Zuma. Again, interesting, but we'll see the reasoning for that. So on that, they agreed with the Electoral Court. And then there was this question of, is the conviction a conviction for the purposes of Section 47(1)(e)? Again, Zuma and the MK party arguing that because Section 35 rights, these are fair trial rights, were denied initially, that in some ways changed the nature of the conviction, and it wasn't the kind of conviction that could have fallen within the crosshairs of Section 47(1)(e). The court saying once you're convicted of an offense, it's a conviction, and a conviction is a conviction. There are no separate or distinct kinds of conviction, even if the process to get to that conviction is different in civil and criminal matters, and contempt falling kind of awkwardly between the two, and Mr. Zuma's case being purely through civil procedure and motion proceedings didn't change the nature of the conviction. So what we know is that this is the end of the legal road for President Zuma as far as South African courts are concerned, and that the commission has won this appeal. The court was unanimous. The Constitutional Court is the highest court in the land. And that's that. We operate on principles of legal finality in South Africa, and that is the end of the legal road for President Zuma. Now, what could he do? He could approach some kind of international body if he still thinks that there's merit in the case. And I did mention an interesting case, the case of Disanayake, which actually came up in the hearing of the court, where the International Covenant on Civil and Political Rights, which is an important international treaty, also looks at questions of people's ability to be or not to be candidates in its Article 25. And there was an interesting similar case where a Sri Lankan cabinet minister was convicted of contempt of court, by the apex court in Sri Lanka. It was a similar sentence. It was a similar disqualification. I think that disqualification was 7 years, whereas Zuma's is now 5 years. This case was taken before the UN Human Rights Committee, where they found that merely disqualifying Mr. Dissanayake on the basis of a contempt judgment, even if it came from the Supreme Court of Appeal, was disproportionate and infringed his civil and political rights as understood by the Human Rights Committee interpreting the International Covenant. So that case seems very similar to the Zuma one. And I suppose one question would be whether Mr. Zuma has the gall to approach the UN Human Rights Committee and say, hey, you ruled this way in Dissanayake. My case is very similar. What say you? The Human Rights Committee is not necessarily binding in the same way as the ICJ, but it does interpret this very important piece of international law. So there's that. But look, this election is not far away. And I guess the ultimate question as I move on to the politics now is, does President Zuma actually really want to go to parliament? Because that question has never been answered by the MK party. Now, of course, they went all the way to the Constitutional Court to make sure he could go. That could be seen as an attempt to argue principle rather than practice, because whether he would go, I think, is still an open question, and I doubt that he would have gone, even if he was disqualified. However, what does this mean for the MK party? Because the MK party has been on a rolling series of victories, and this will be seen as, this is a setback for them. It's the first big legal defeat that they've suffered. And so losing never looks great in elections. You always want to be on a winning side, on a winning team. So this won't look great for MK. It has also been dealing with its own internal challenges, which have seen it dip somewhat in the polls. However, just before this case, it began rising again in the polls. So on the one hand, the party didn't win, and that's never a great thing. On the other hand, as I have constantly argued, the MK was in quite a strong position with this case, because if they lost, they could say, well, the court is always against Zuma. Zuma never wins in the ConCourt. So we knew that was always going to happen anyway. But to the South African voters, this is not an election about the courts. This is an election about you. And you can still vindicate President Zuma by coming out in your numbers to support MK. So they could rely on a victim narrative, a narrative of persecution in which they can cast the court as being perennially biased against Mr. Zuma. So I think that's probably what we'll see them doing. And when we look at some of the statements that have been made, we haven't got an official MK statement yet, but I've looked at a few people connected to the party, Andile Mngxitama, Dudu Zuma as well. They've both said a similar thing, which is that doesn't really matter. Zuma's still on the ballot, and we still urge you to vote for the MK. And I think that's probably true, to be honest. Do people really, when they go into the voting booth, are they thinking who's on the list? Should I vote for who's on the list? If I were to ask you exactly what number, from number 1 to 10 on the ANC's list right now is, would you know the answer? Probably not, right? So I think people are voting based on the ballot and in the knowledge that Zuma might not have gone to parliament anyway. However, had he won, I think that would have also been good for the MK party, because then they would have rode this wave of successive court victories and taken that momentum with them into the election. Now, the MK party still looks to be a fairly strong political force. They recently filled up Orlando Stadium in their manifesto launch. And I think we kind of have a sense of the size and the scope of MK. They're doing exceptionally well in KZN, where in some polls they're actually the number 1 party. They are at around about 10% nationally, so we'll see, give or take, what happens. More internal ructions will probably take them closer to 8. They can hold together and build from this point, we could see 11, 12. So that's where they are. And what does this case mean politically? Not much, in my view. I don't think it particularly helps MK hugely. I don't think it hinders them hugely. And I think that they have ways of spinning this judgment in their favor. And having already won Zuma's face on the ballot, the right to contest, and the right to use the party logo, they have already won the most important cases in the build-up to this election. This, I think, would have been very much a cherry on top. And the fact that it went all the way to the ConCourt further zoomed in on or accentuated the importance of this case. But here we are now. So I must say, though, I also think this could be good for the ANC. You saw President Ramaphosa celebrating, pumping his fist at this result. And he's one of the biggest beneficiaries of this judgment. I think the ANC will be emboldened to say, well, we told you so. They're attacking Zuma. They're trying to paint Zuma as someone who is a constitutional delinquent. And so the damage, any damage they can do now, and I suppose they can turn around to their base, just as MK can turn around to its base and say, hey, look, this person that we, are putting through disciplinary procedures, this person who has turned their back on the ANC has now in turn had the ConCourt turn their back on him. We were right. Stick with us. We are renewing, and this is another sign of that renewal. So I think the ANC will be able to use this to their advantage. And often there are many different winners coming out of a court case. We saw President Ramaphosa saying some interesting things. He said that, we've given, this was in an interview with Clement Manyatela and Matsidi Somadia on 702 earlier, which was happening at the same time as this judgment. Hey, South Africa's lit today. We've given the right to courts to arbitrate disputes against us. I note the ruling, and that is what it is. So President Ramaphosa taking his typical cautionary stance, not saying anything crazy, but just saying, the court has ruled, and that's that. He also said, though, that former President Zuma should be the one person who should respect the rule of law. We won't mince our words. And that was in a response to a question about, could there be violence here? And I do think that is an interesting and an important question to watch. We can't deny that the July unrest of 2021 had something to do. Exactly how much and the proportion is something for historians to tell us in due course, but had something to do with former President Zuma's incarceration. That at least was a triggering event. So we know that when the Constitutional Court makes rulings that send Zuma to jail or disqualify him, there will be a large group of people in this country who feel intensely aggrieved by that and who believe that Zuma gets special and unfair treatment, particularly when it comes to courts. So the question is, what prospects are there for unrest? Well, when I look at MK's statement so far, I don't get the sense that we will see, the kind of upheaval that we saw, and goodness forbid that we ever do again. I do think that we may in the next few days get some more aggressive statements coming from MK, and I think that is fine. People are allowed to be aggrieved by judgments. They must respect judgments, but they don't have to concur with them. In fact, that's what academics do all the time. They disagree with court judgments. But I think it is one just to keep an eye on, because this court judgment will add a certain air of volatility to the election. However, I think that this election is so close that everyone, including MK, is now just focused on the actual polls and trying to do as well as possible. And so It's not clear to me that right now, as we sit, we face a prospect of things descending into violence or chaos. But it's one to keep an eye on. So what I would suggest is keep an eye out for MK statements. Keep an eye out if former President Zuma makes statements. And let's take it from there, because previously he wrote this long letter about the ConCourt, which in some ways made many of his supporters feel that he had been treated very unfairly. So let's have a look. We're going to be speaking to none other than Ugogo Aubrey Machikri soon on this channel. You're one of your favorite guests, and this will be a question I'll put to him because he always has very insightful takes on what the consequences of these kinds of legal political decisions might be. So, in sum, I think a judgment that is neutral politically for the MK, despite being a legal defeat. One that they can use to their advantage if they're wise about it. And that's how I would play it if I was an MK strategist. I'd say, yeah, look, of course the ConCourt ruled against us. Then when would the ConCourt rule for us? But the fact of the matter is, no matter who's trying to stop us, we go marching onto this election. And we will continue to be the game changer of this election. ANC can also take this and run with it. I think it's fairly neutral for all of the other political parties who have kind of kept quiet as this has unfolded. So there we are. A very important moment for our democracy, one in which the Constitutional Court has been under great scrutiny, and one in which I think democratic institutions will ultimately hold. There will be justifiable frustration, but the ConCourt will remain the ConCourt, and Parliament will remain Parliament, and the election will remain the election. That's my take right now. So help us get to 100,000 subscribers before this election is done. We are narrowing in on that figure. We need like 4,000 this week. So help us to get there. Like, share, and subscribe. If you're listening on a podcast platform, please give us a positive 5-star rating. And let's continue this conversation in the comments. What do you think? I know there are some fascinating legal minds here. What do you think of the judgment when it comes out? And when you've read it, what are your thoughts? What do you think the political implications will be? And let's continue this conversation all the way to the 29th of May. Aye.